Carissa Danes with Easy Button Employer Relations here. Happy Paraphrase Friday. I am home visiting my friends and family this weekend in La Crosse. So I did want to come on here and talk to you guys a little bit about the Supreme Court's decision regarding Starbucks and the NLRB. So let me give you a little bit of backstory here. So in 2022, there was a Memphis store that was working on unionizing, creating a union within their store, or to add to the unions that were already being created within the Starbucks organization. And they're calling these employees the Memphis 7 because all 7 of these employees actually ended up being terminated for a violation of company policy. So what they did was they brought media people in after hours and let them take video and stuff of this store. So direct violation of company policy. All 7 employees were terminated. They, of course, went to the NLRB or the National Labor Relations Board and said, hey, we were terminated because they're retaliating against us because we're trying to unionize our store. And so what happened was this obviously went to court. And while this was going to court, the NLRB kind of inserted what they call their 10J injunctions. And so that means that they can ask for temporary relief for an employee. And so if there is reasonable cause to believe that unfair labor practices occurred, they can go into the federal court and say, hey, we feel like this is definitely clear that there was unfair labor practices here, and we're asking that all of these employees be reinstated with their position that they were in at Starbucks. And so the lower court decided, yep, they need to go back to work. We need to put them back to work. And so Starbucks obviously obliged. But what they did do was they did kind of keep appealing this all the way up to the Supreme Court. And really what their argument, what the Supreme Court ended up picking up was they ended up picking up the component on how these decisions are decided. Because Starbucks is saying, wait a minute, we're still going through court. Like, we're still going through this process. Why are we reinstating these employees when we're still going through this process? And so one of the arguments too is that, the NLRB is the one that's controlling these processes. And so, this could be a temporary injunction that lasts forever. I mean, they're the ones that are kind of, this is really kind of in their control. And so what the Supreme Court did decide that they were willing to take up was they decided that they were willing to take a look at what standards or what review these appeals courts are looking at, or the tests to decide whether they need to apply this 10J that the NLRB is trying to argue. While they found, when they were actually looking at these appeals courts and deciding, or looking at what these people are doing or what these courts are doing to make these decisions, they found that there was a ton of inconsistencies. So what they're saying is that 5 appeal courts, including the one where this case actually came up, were basing their decision on a 2-part test. So they were asking the courts determine whether there's a reasonable cause to believe an unfair labor practice had occurred, and then they were looking to determine whether granting an injunction would be just and proper. 2 steps. Then they talked to 4 other appeal courts that were saying, the court asked whether the unfair labor practice case is likely to succeed on the merits in establishing that labor violations occurred. Second, they looked to see if the workers the NLRB is attempting to protect will face irreparable harm without the injunction. Third, after showing likelihood of success and irreparable harm, they asked whether those factors outweigh any hardships the employer is likely to face due to the compliance with the court order. And then, of course, they look at whether issuing the injunction serves the public's interest. What they also found was that there's 2 other appeal courts that are kind of doing a hybrid. They're taking a little bit of this and they're taking a little bit of that. So what the Supreme Court decided today is that all appeals courts need to follow the same test. And so this is going to be huge, because if the NLRB had brought this case to an appeals court that would have ran a 4-part test, it could have been very possible that they in fact wouldn't have been reinstated. The employees wouldn't have been reinstated. So this really wasn't necessarily Starbucks arguing that the employees should or should not have been reinstated, or there was or was not unfair practices. But what they wanted to be looked at was the steps in which were taken in order to make that decision, and having consistency across all appeal courts. So this is super interesting. This is huge that the Supreme Court was this involved in something like this. And I really think it's gonna kind of change the NLRB's approach. And also, like, the NLRB is winning 90% of their cases right now. And so, we're not, I think a piece of it is that, there's this inconsistency within the appeals courts on how they're making these decisions. But also, I do think that employers just kind of back down, just kind of do whatever they're asking them to do because they're concerned that they're going to lose anyway. And so I think there are some interesting things that are going to come out of this, and it'll be interesting to kind of see how it all unfolds. But I hope this is helpful to you guys. If anything, it's interesting, and I hope you have a wonderful weekend. If you guys are interested in talking to me about the services that I provide as an HR consultant, which is specifically compliance and workplace investigations, I'd love to chat with you. I also do offer subscription every month where you get an hour of my time to talk about whatever HR issues that you have going on within your organization or you need some guidance on. It's very inexpensive, beautifully built for small businesses, and we always end up finding something to talk about for an hour. So Carissa Danes with Easy Button Employee Relations. Stay out of trouble out there.